Matthews. Joining us now, Christopher Green, law professor at the University of Mississippi Law School. Professor, good to see you again, sir.
Good to see you.
All right, so we wanted to get you on to talk about this recent ruling handed down by the Supreme Court concerning social media companies' liability for user-produced content. This has been going on a while, has it not, Professor? I mean, I've seen lots of news and reports and discussion about it. Finally got it in front of the court and have received a decision. First, explain the premise of the case, and tell me, Professor, were you surprised at the decision by the court?
I'll answer the second question first. I wasn't terribly surprised, but basically, they're suits by victims of terrorism. So the ISIS folks, they do terrible things, and they use the internet to do so. So they use Facebook, they use YouTube, they use Twitter. So you have all these technologies that essentially allow anybody, any group of people, to find other like-minded people. So you can use technology to do good, and you can use it to do terrible things. And the thing is, these algorithms, they provide really specialized, if you click on a few videos, YouTube will say, hey, sounds like you're interested in jihadi stuff. And they'll just, it's a technology that enables people to find like-minded people of any, it just has a moral neutrality to it that is really dangerous. So these lawsuits, there were two different ones, but they said, hey, you people are helping terrorists, and in the sense that, the phone company helps terrorists because it's easier to coordinate a group of people if you've got a phone. The mail system helps terrorists. So basically what the court did, so that's one piece of it, is this aiding and abetting of terrorism? So aiding and abetting was the key term in a statute. If they had said it was, so the court unanimously said it was not. If they had said it was, then there would have been this big, huge question, which has been looming since 1996, the Section 230 of the Communications Decency Act, which is this big, it's an immunity for internet folks of uncertain size, and it remains of uncertain size because the court did not touch that aspect of it. They said, because the Anti-Terrorism Act aiding and abetting provision doesn't apply to what the big internet folks did in this case, we don't have to get to the 230 question. But the 230 question is looming. And really, the aiding and abetting question is also something. But for both those issues, Congress could step in and clarify it. Anytime they wanted. And of course, the question is, when does Congress get their mind together? Well, as we see with the debt limit negotiations, it's a bicameral system, and that is. Gridlock is very frequently what we see. But this is the kind of issue that you could almost imagine a bipartisan group coming in and writing a more specific rule other than the 230 rule. Maybe possibly posing some kind of compensation requirement on the internet folks for terrorism even. But not looking too likely in Congress anytime soon.
So there's clearly been a movement, I would say, as you point out, on both sides of the political aisle to shall we say, rein in big tech. That's kind of the refrain you hear a lot. We got to rein in big tech. And both sides feel like that big tech, to a great extent, is their enemy in some cases, and I think there's some tendency on both sides to want to leverage big tech to their benefit. Does this Does this put an end to that movement?
Absolutely not. Essentially what they're doing in this case is just looking back to a statute and saying, does this aiding and abetting of terrorism provision apply to the kind of aiding? It is an aiding of terrorism in the sense that any kind of technology provides some sort of aid. So textually, the argument wasn't completely laughable. It doesn't if you say that Twitter's aiding and abetting this particular action. Really, they're aiding and abetting almost all crime that involves people connecting using the internet, which would be just, wow, that would, you want to be careful. But the idea, so the idea is, okay, we've got this technology that produces a huge amount of value. It improves people's lives in a lot of ways. It makes them worse in certain ways. And the argument is, well, should the people whose pockets are being systematically filled by the benefits of this technology, shouldn't they have to compensate the people who suffer the harms? And I mean, I think it's very unlikely that they're going to just carte blanche say, oh yeah, okay, our new compensator of crime victims is Twitter or YouTube or Facebook. But the idea that, hey, these people are profiting a lot. They have a kind of quasi-public status in certain ways. They are kind of the people running the infrastructure of this system. So the idea that some sort of equality norm can be imposed on them. Different people from both the left and the right have been attracted to that idea, and I think that is definitely gonna stick around.
Okay.
And it's the same rule that for hundreds of years we've applied to people like people who own bridges, people who have a strategic resource at a critical juncture. Very frequently, the law will step in and say, okay, you get to make your money off of your bridge, but you got to charge everybody the same price. You can't pick and choose in order to kind of take advantage of people in a vulnerable situation. So that argument, I think, is going to have a lot of intellectual heft and political heft for the foreseeable future, I think.
Yeah, and of course, you made a point a minute ago. It's kind of difficult just to sort of put a fence around social media companies and say, oh, yeah, well, they're the exclusive enablers of this, because you've got a myriad of technology infrastructure behind the scenes and underlying that's required for their tools to even function. Could you not maybe, if the court had ruled differently, is the next step in that extending that to all the telecom carriers, for example, and all the makers of all the network electronics and a bunch of that? I was in that business. It's gigantic.
Oh yeah. I mean, and Justice Thomas's opinion, he goes through these kind of analogies that, well, I mean, they're not really, they're using the internet for the same kind of stuff they would have just used a phone for. And but if you remember, I mean, when the cell phones started coming out, once they started coming out with burner phones, like, man, I mean, the drug industry is never the same, because, oh man, if I got a burner phone, I can just instantaneously get in touch with people, and I can toss it in the trash after a few transactions, and the cops can't trace it. So the game of cat and mouse, it's tempting. This particular time really is one where the tech people ought to be helping out more than they are. So a lot, the oral argument on all kinds of details about, well, how exactly do these algorithms work, and the customized stuff. It's not crazy to think, well, maybe we should require them to be a little bit more careful about giving targeted advice about, hey, meet your criminal friends. And I don't think there's anybody at these companies that is genuinely like trying to promote ISIS or something. But the question is, at what cost? Do we want to demand that they do more to prevent crime? And on the statute, the way it's written now, pretty clear case when you get a unanimous Supreme Court that it's this is not the statute that's going to do that.
I got you. So you think maybe there's legs here, that there's still going to be calls for political leaders on both sides of the aisle to so-called rein in big tech, whatever they mean by that, because I think it has different meanings depending on who's making the statement in the context.
Oh yeah. It's easy to get a party to, let's have a big rein in big tech, and then you get there, and then the details like, oh well, I want to rein them in by making sure they don't discriminate against Republicans. The other people like, well, I just want them, to give money to my pet causes, and sometimes these are diametrically opposed demands that people want to put on big. Yeah. Some people are saying they're not discriminating against conservatives enough, or something.
Yeah, exactly. That's exactly right. Professor, always. Absolutely. Professor, appreciate your insight. Always enjoy talking to you, sir. You have a good day, and I'm sure we'll talk soon. Thanks a lot.
Great to see you. God bless you.
Yes, sir. Christopher Green, law professor at Ole Miss, has been our guest here talking about this recent Supreme Court decision that says that big tech is not responsible for certain user-created content. We're coming right back in the Element Wealth studio. Stay with us.